This episode is brought to you by Choiceology, an original podcast from Charles Schwab. Choiceology is a show about the psychology and economics behind the decisions we make every day and how to make better ones. I'm Dr. Katie Milkman. Join me as I share true stories from Nobel laureates, athletes, authors, and everyday people faced with monumental decisions. We'll share useful tools and strategies to help you make better decisions in your own life. You can find Choiceology at schwab.com/podcast or wherever you listen.
Sign up to The Economist for in-depth curated expert analysis of world events and topics ranging from business and culture to science and technology. You'll get the weekly digital edition, online-only articles, curated newsletters on politics, the markets, science, culture, and China, and full access to The Economist Podcast Plus. The Economist is independent journalism for independent thinking. Go to economist.com and get your first month free.
Hello, welcome to the final part of How Originalism Ate the Law here on Amicus, Slate's podcast about the courts and the law. I am Dahlia Lithwick. Over the past couple of weeks here on Amicus and at slate.com/originalism, we have been building out a comprehensive package of written pieces and podcast episodes that serve as a resource for understanding this term and beyond at the highest court in the land. How we got here, where we're headed, and crucially for this final episode, what we can do to change that trajectory. We originally released this episode to Slate Plus subscribers back on May 18th. This endeavor and its reporting would have been wholly impossible without the financial support of our Slate Plus subscribers. From the hours and hours that our team spent poring over law review articles to interviewing experts and listening to so many hours of the Bork hearings, to our ability to bring guests together for this special panel, one of whom came all the way from Hawaii, to the fantastic, memorable art that we were able to create to bolster this series. All of this work requires resources. So just a massive thank you to our Slate Plus subscribers. We literally cannot do this without them, which is why we were so happy to share early access to this episode with our Plus members. If you would like to join Slate Plus, you can do so by clicking Try Free at the top of our show page on Apple Podcasts, or visit slate.com/Amicus Plus to get access wherever you listen. Your subscription gets you access to weekly bonus episodes of Amicus, pop-up emergency episodes when big legal news strikes, and ad-free listening to Amicus and all of your other favorite Slate podcasts. On to the episode. Let's head together now to Washington, D.C. and to our live show from last week, recorded at the historic and ever-evolving 6th and I. Okay, friends, we have now reached the part of the journey in which exceptionally intelligent people are going to come onto this stage, have just come onto this stage, to beat us out of this sense of like torpor and hopelessness and surrender. So let the beatings begin.
Please welcome Associate Justice of the Hawaii Supreme Court, Todd Eddins.
And just to be clear, he did not take the metro to get here. He flew to be with us, and we are so
on a private jet.
Are you sure it wasn't a luxury RV, or?
Okay, get it all out. Everybody just get it, work it out. And Madiba Dennie is a lawyer and author of the about-to-be-published utterly brilliant Get Your Pre-Orders In Now book. It's called The Originalism Trap, How Extremists Stole the Constitution and How We the People Can Take It Back. Madiba Dennie is also a deputy editor of Balls and Strikes, and also really, I cannot tell you, someone who is thinking so hard about this issue at exactly the moment that we need you. So Madiba and Justice Eddins, thank you for being with us. So look, over the 2 weeks of this podcast and print series about originalism, we have examined the historical falsehoods. We've exposed what we think of as the three-card Monty that is originalism. You've just heard Professor Eiffel's expert testimony on the path for a deeper, more thoughtful, more rigorous understanding of the founding. And now we're going to turn to the two of you for a little bit of an understanding of how we move forward. And Madiba, I thought we would start with you and this alternative approach that you are advocating. Not originalism, not living constitutionalism, something radical and new. So if the theme of this panel is what do we do about it, I would love to hear from you about your arc out of this morass into something better and something we deserve.
Well, I want to give a little bit of background first, because you mentioned living constitutionalism. So I want to say that with originalism, the idea is that the meaning of the Constitution is frozen in time. You have Justice Scalia who said, it's not a living document, it's dead, dead, dead. And so then you compare that to living constitution, where the living constitutionalism idea is actually it is a living document, it evolves, it changes, it grows over time. And I think that's true, but I think where the idea of a living constitution falls short is it doesn't say how it lives. It tells you that the Constitution changes without saying in what direction it should change. It's more descriptive than prescriptive. So what I've tried to do is put forth a way of how our interpretation should change. And I call this inclusive constitutionalism, because the idea is that the Constitution includes everyone and should function in a way that makes the promise of a multiracial inclusive democracy real. So I think that when we interpret any provision of the Constitution, we should be doing so through the lens of the liberatory goals of the Reconstruction Amendments. That provides us our sort of compass on how we make that change, of how we go forward. So yes, the Constitution does change, it is alive, and this is how we should live.
Justice Eddins, you say that, of course, jurists have always looked at history. It's just that they had a bunch of other tools in their kit, too. And that the problem is basically that the Supreme Court's conservatives are drunkenly stumbling into a casino with a bag full of stolen chips, betting it all on bogus history called originalism, to the detriment of every other way that courts traditionally do law. Can you talk more about that?
Well, also, Mark was paraphrasing. He never said anyone was drunk or stealing.
Well, I'll say they're perhaps playing Russian roulette with our lives. As I see it, and by the way, aloha, everyone. I'm just honored here to share the stage with such brilliant thinkers and just top-notch legal journalists. But if you look at Obergefell is 2015. In that case, which was really only 8-9 years ago, interpreted the Constitution the way it was always interpreted, in looking at the text and the history and more, the purposes of the Constitution, the values of the Constitution as a whole. Also, it looks at human dignity, and that's the way we approach our Constitution in Hawaii. We don't just focus on simply the text. We just don't drill down into history and try to cherry pick parts of history to support a preferred outcome. We look at everything, and everything generally means the values that the Constitution inspires, the spirit of the Constitution, the purpose of the Constitution. And when you look at things in that type of generality, you have really, really sound decisions that respect human dignity.
Madiba, one of the things that I think you think about, it's such a through line in your book and your work, is that originalism is not just a sort of modernity suppressing project, not just a inclusivity suppressing project, it's also a democracy suppressing project. The aim is to invert what we think of as democratic rule. And I would love for you to sort of pick at a little bit the ways in which this fundamentally upends the way we continue to do democracy. And as such, it's not just sort of stalling progress and calling it history. It's also stalling the way we become a better democracy.
Right. And I think it does so in multiple ways. Probably the most obvious way is that it chains our sense of constitutional interpretation to the idea of what this handful of 20-year-old, 30-year-old-ish slave-holding white guys one summer, as they were really busy hashing out some compromises, what they came up with and like what they think those guys had in mind, and says that that's it, that's all you can do. So that's already very undemocratic, and that you're chaining your interpretation to this time when the overwhelming majority of America was much worse off. But there's also another way in which it's undemocratic, and that way is that it outsources our responsibility for thinking about what the Constitution means and how we should be applying it today, and says, actually, all of us in this room today, you don't have any say. It was already decided by aforementioned slaveholders. And so you don't get to really participate in any form of democratic governance. You don't interpret these rules that you have to live by. And that's really contradictory to the idea of democracy, that we have a say in these rules, that we make and interpret these rules. So you are taking away our self-governing power, and not only are you taking it away, you're not even giving it to somebody good.
Can I just quickly, Madiba, ask a personal question that I think will resonate with a lot of the people who are unfortunate enough to be lawyers in this room? In your book, you talk about falling in love with the majesty and the promise of the law, and then crashing back down to earth as you discover that the law consistently fails to live up to that promise and frequently actually does harm to the most vulnerable. And yet an arc of your book is sort of that you fall back in love with the law again.
Love is a strong word, Mark.
Let's say you enter a situationship with the law. Tell us how you reached that stage of defining the relationship.
Yeah. The law and I are friends with detriments, but we're working on it. But I think, here's the thing. I think that the law obviously has been used to inflict a lot of harm on a lot of people. But I think that also is indicative of the power that the law holds. And that shows us that, like, we can choose, because again, this is a democracy, we have a say, we can exercise these choices. We can choose to use the law differently, to interpret the law in a different way, to change how the law works. So I think that I guess I haven't given up on the law insofar as I haven't given up on us, that I believe the people have the power to determine how the law functions in society, and as a result, the law can function in a better way.
Okay. I won't wait for the New York Times wedding announcements, but very encouraging.
This episode is brought to you by Shopify. Whether you're selling a little or a lot, Shopify helps you do your thing, however you cha-ching. From the launch your online shop stage, all the way to the we just hit 1 million orders stage. No matter what stage you're in, Shopify's there to help you grow. Sign up for a $1 per month trial period at shopify.com/special offer, all lowercase. That's shopify.com/special offer.
McDonald's presents Burger Reviews by Hamburglar. Today's review, the hotter, juicier classic burgers. Mr. Hamburglar, robble. He said, of all the McDonald's burgers I've ever hamburgled, these are the hottest, juiciest, and tastiest. Robble.
Hamburglary is on the rise. Get caught with a medium double cheeseburger meal for $6. Price and participation may vary. Promotion pricing may be lower than meal price. Comparison to prior classic burgers.
Ba-da-ba-ba-ba.
Justice Eddins, you said to us, and I think this is really powerful, that every June you watch as the Supreme Court's conservative majority turns settled law into unsettled law. Can you talk to us a bit about how that affects you from your position as a state Supreme Court justice trying to make sense of all of this and actually apply it?
Well, when I'm sitting out in the middle of the Pacific Ocean, enjoying myself, no worries except the day-to-day routine, and then we have some of these opinions drop. And, it really is now our life that precedent is advisory. And I've said that I believe it, and I've heard this before, people have said precedent is for suckers. And that's what originalism really stands for. Because in the Dobbs decision, when the court said, Roe versus Wade and Casey were egregiously wrong, that was because those courts did not use and operate under the originalism precepts. So anything that doesn't operate according to originalism is fair game to become unsettled. So what does that do for courts, or how does that work for us? And judging is a hard job. It's demanding. There's so many aspects of the job that really demand thought, time, hard work, energy. And when the landscape is constantly shifting, not just in June and May and even in February, it seems now, it's hard to operate because not only judges and justices, but the lawyers, the parties, the people who work on preparing cases, if the law just suddenly switches in a heartbeat, that breeds chaos. The law is, and the rule of law is all about stability, it's durability, it's predictability. And when things tend to just change, mainly because the court's composition changed, it's really tough for judges, justices, and the lawyers, and even the public to understand things. And it breeds chaos. To me, it's a lack of respect by the current Supreme Court and all the great decisions that have come before it. I mean, you're talking about Hall of Fame jurists. You're talking about throughout the American judicial system, judges and justices who've operated on the normal way to interpret the Constitution. And what these folks are essentially saying is, you all got it wrong. We are right. And that is why I said in the opinion that, we have a bunch of hubristic originalists right now running the show. And it's possibly not going to get better because a not-so-secret society seems to be grooming others to fill the benches. They're just politicians in robes at this point. I came from a background and a culture that prides itself on experience. I mean, you don't rise to the judiciary in my state unless you have experience in being a lawyer and seeing things and understanding that what you do affects lives. And I think this court does not really get that what they do has consequences. And they're really unleashing misery every June.
I think it's not, yeah. It's not an accident in some sense that this, opinion that you write has to do with guns and lives and people dying. It's, been a through line in this originalism series that this is not an academic debate. People die. And yet I think that you are sort of caught on the seam between two imperatives, and I'd love, Justice Eddins, for you to unpack for a minute. On the one hand, you're clearly someone who believes deeply, fervently in the law and the rule of law, in the need for stability and for institutional regard for the judiciary and precedent, as you've said. You're also someone who's been willing, I think, to call out when that goes horribly awry. And I guess I would just love for you to explain to us why it is that you felt that you needed to do the thing that not a ton of judges have done, which is say, I stand proudly as a jurist, I believe in the law, and also whatever this is not that.
I guess the old adage was that, justices who write opinions, you should be read, not heard. And, so I did that. I've written certain things. But I also felt that I have a unique role. I mean, I'm just so honored to do what I do. It's just such a joyous job. I have incredible colleagues at the Hawaii Supreme Court that I thought there needed to be something more, I guess, an external voice to combat an interpretive modality of the Constitution that I feel is absolutely insane. I mean, to think that we're going back on the public meaning of the Constitution as interpreted by, Thaddeus the Candlemaker or, Clement the Cobbler. I mean, to what they understood back then is now controlling contemporary lives with contemporary problems. I mean, it's just absolutely nutty. And, I feel I have a responsibility to call them out, basically.
And I just want to offer huge respect, because that is not a thing that we see, in my view, enough of. And I think that waiting around for it to get worse is a pretty chilling proposition. Madiba, I think what we loved so much about when we talked to you on the podcast was your insistence that justice is not a thing that we watch the courts do while we sob softly into our beer. We have to care and we have to get involved, and that does not require that everybody be a constitutional scholar. It just requires getting involved. Can you talk a little bit more about what all these folks can and should be doing to write themselves into the project that we've all seemingly been written out of?
Yeah, I think you're absolutely right that the Supreme Court has been working to write us out of this project. There's been a sort of collective abdication almost of our responsibility for interpreting the law. And there are so many ways that exist for people to actually be more involved in shaping constitutional meaning every day. There are opportunities to shape constitutional meaning beyond once every 4 years at the ballot box, although obviously that is one such opportunity, whether you're voting for the people who will nominate judges and justices, or depending on what state you're in, if you're voting on the judges themselves. So that could be an opportunity right there. You can say the Constitution is now a campaign issue. We are not voting for originalist judges. But also, there are things folks can do to shift how people think of what the law means or requires. And we know this because we've seen it done. We've seen the right do it with chipping away at the right to abortion over the past several decades until they were able to finally outright overturn it. But even before they got to Dobbs, abortion was inaccessible in much of the country already because they had so cultivated power and the belief that actually Roe was wrong, so we can do things differently. And I think that that's something progressives should really embrace, of saying the court is wrong and we're going to do things differently, whether that is by passing contradictory legislation, the same way that anti-abortion states pass trigger bans. I think we should be passing trigger laws for democracy. I think we should absolutely say things like Citizens United was wrongfully decided, and so we're enacting this campaign finance law, and just dare the court to do something. I think that we should be engaging in forms of protest or boycotts. One of my favorite examples, and I mentioned this in the book, is that I don't think you can understand the Supreme Court striking down the segregated bus system in Montgomery, Alabama, without accounting for the tens of thousands of Black people who had been boycotting the segregated buses in Montgomery, Alabama. I think that they changed the terrain on which the court's decision-making could happen. And so so like that's something that people need to do. Like we can declare what we believe is constitutional or not and act accordingly, like put our constitutional vision into practice, whether they be by trigger laws or boycotts or any other form of legislation. These are things that people can do in all sorts of creative ways. There's always an opportunity to push back, and I think people need to remember that rather than just sort of accept what originalists are selling us of, well, this is all there can be.
So while we're on the topic of pushing back, Justice Eddins, you have done some pushing back yourself. Dahlia mentioned the Second Amendment case that came to your court where you essentially refused to adopt the U.S. Supreme Court's interpretation of the Second Amendment when interpreting the Hawaii Constitution, even though the Hawaii Constitution has the exact same words as the federal Second Amendment. You said, well, the U.S. Supreme Court got this entirely wrong and we aren't adopting that steaming pile of garbage into our Constitution.
Again, he did not say steaming pile of garbage.
I thought that, though.
And so I think that's one example where you can push back. I'm curious if you see other opportunities that state Supreme Court judges and justices like yourself have to provide a check on the Supreme Court's rampage.
Well, I certainly do. And, in our system of federalism, it's a dual sovereignty system where the states have their own constitutions. And in fact, if you look at the Bill of Rights, it was really cut and pasted from state constitutions. But we can interpret our constitutions to give greater protection than the counterpart federal constitutions. So that's one way that states can really make sure that their people are not governed by the whims of the United States Supreme Court, because you can provide your states greater protection. And you're seeing that, and I think Dobbs really provoked awareness of state constitutionalism like no other case before, because now you're seeing, constitutional amendments in various states, and that's one way that the people can sort of get involved. Unfortunately, only 18 states have voter-initiated constitutional amendments that can be through voters. But you're seeing in these states where citizens are getting active, they're not liking what the United States Supreme Court has deemed appropriate as far as government regulation of personal autonomy. So that's one way. I think state high courts also are not beholden to originalism. I mean, state high courts can interpret the Constitution just like it always has been interpreted, and that's the way we interpret it. Other state high courts can do that. Federally, I also think there can be judges who interpret the Constitution the normal way as well and let the chips fall where they may. There was some great decisions from Judge Aiken and Judge Staten in the Juliana climate change case that basically interpreted, the substantive due process to include a right to a stable climate system. Now that got knocked down, but those were bold decisions. And in fact, it was a decision that inspired our court to be the first court to recognize the right to a stable climate system. So I think I don't think judges and justices need to just sit there and take it. If you get overruled, who cares? At least your opinions are out there for posterity. I mean, that's why you have dissents anyway. I mean, dissents are really there for history. And a more reasonable approach might surface later. And I think courts do have the responsibility to not just lockstep with what the United States Supreme Court is doing.
I agree wholeheartedly, and I just want to tack on just a little bit more. As far as dissents, I wouldn't even say they're just for history. I think that they're also for now, in that they can have a mobilizing political effect. And that, I think that people can rally around this to sort of point to, it's not just me, your fellow judges also agree that you got the law wrong, and you can say that this dissent is a roadmap to a future majority opinion. And I also wanted to second your thought about federal judges too can use this sort of power. I think that federal judges are sleeping on their job security. and that they could be bolder about putting that to use and distinguishing the Supreme Court's harmful opinions in the same way that the Supreme Court sometimes honestly ignores precedent by saying, oh, that's not relevant because of reasons. There's similarly not actually a reason that lower courts can't do that and say, yes, the Supreme Court said this, but this case is different. This case has different circumstances, and so what the nonsense the Supreme Court said does not govern the outcome here.
Hi, I'm Katie Riley. On the Slow Newscast from Tortoise, Donald Trump became the first former U.S. president in history to face a criminal trial.
The defendant repeatedly made false statements on New York business records.
This is not a trial. This is not an act of criminality.
We cannot and will not normalize serious criminal conduct.
This is the story of his first week in court, told through the transcripts. Listen now to the Slow Newscast wherever you get your podcasts.
Hey folks, I'm Preet Bharara, former U.S. Attorney in Manhattan. On my podcast, Stay Tuned with Preet, I break down legal topics shaping today's news. And I'm joined by thought leaders to explore topics at the intersection of power, policy, and justice. In our increasingly complex world, clarity can feel elusive. My goal is to empower listeners with knowledge and insight during these transformative times. So I hope you'll join me every Monday and Thursday on Stay Tuned. Search for and follow Stay Tuned on Apple, Spotify, or wherever you listen to podcasts. Stay informed, stay empowered, stay tuned.
So I'm going to ask everybody to loosen your tie, pour yourself a drink if you are not already drinking. Avid Amicus listeners are very familiar with the Amicus Plus cigar bar. It's where our Slate Plus members come to hang out with Mark and I for our constitutional law / Supreme Court dread and after party. Real dread recently. So this is the part of the evening where our expert panelists get to answer some questions from our really extraordinary Amicus Plus members. And I have to say, we got a mailbox full of really smart questions, in no small part based on the work done by the panelists. We could dedicate an entire hour to answering those questions, but for purposes of brevity, we just picked 2 questions that we're going to thank our Amicus Plus subscribers for sending in, and we're going to read them to you now.
So our first question was a similar question that we got from Roy Pulvers and Chip Moore. Thank you, both of you, which asks, in essence, is there any textual basis in the Constitution for concluding that the framers intended it to be interpreted as forever tethered to the intended meanings of the framers themselves? And I'll just start here. I mean, the answer is obviously hell no. I mean, if James Madison came back to life today, set aside the fact that he would have a stroke the first time he saw a woman wearing pants, I think that he would be aghast to look at what the Supreme Court is doing, because he himself, the father of the Constitution, right? He was very skeptical that language could maintain its meaning across generations and centuries. He said language was inherently cloudy, impossible to nail down with permanent precision because of its inherent inaccuracy and complexity. I mean, these guys didn't even put judicial review in the Constitution. They didn't even explicitly give the Supreme Court the power to do what it's doing. So I think it's pretty extraordinary to imagine that James Madison would have given an A+ to Antonin Scalia getting out some dictionary on his shelf and thumbing through it and saying, well, this says we have the right to bear arms, and arms mean guns, so everybody gets an AR-15 now. That's my first stab. I'm curious for our panelists' thoughts.
Well, I mean, that's absolutely true. You look at Chief Justice Marshall when he's interpreting the Constitution. I mean, he was the first Chief Justice interpreting the words of the Constitution. He said that the Constitution is designed for the ages. And what that really means is it's not fixed. It's designed to move with the ages, with contemporary times. So the history and tradition of the Constitution is evolving. It's pretty much right there. Under originalist thought, it gets knocked out right away simply because the designers of the Constitution did not intend for it to be caged, did not intend for it to be dead, dead, dead.
It's escaping me right now which justice it was that said this, but I remember reading and agreeing with the statement that if the founders wanted us to stick to their understanding of language and only what is written in the text, perhaps they would have used more specific language. But they didn't. They used broad words like liberty. And these are words that what we think about them changes as we debate their meanings, and our understandings of what that means evolves. Also, I would point out the existence of the Ninth Amendment in that they recognize, while being specific and enumerating some rights, they expressly put in a caveat just because we name these rights here doesn't mean you don't have other rights. Please don't take this as an exhaustive list. So I think that should be sufficient evidence right there that they assumed our understandings would change. Oh, and one last thing. There's a quote I love from Thomas Jefferson where he said, "It makes about as much sense for a man to wear the coat that fit him as a boy for future generations to still abide by the Constitution of their barbarous ancestors."
The Constitution is written in open textured language, and it was really inspired by John Locke and those purposes and the spirit of liberty, and it wasn't meant to just be so restricted.
We're going to have to do this last listener question as a Slate speed round, but it's a great question, and I'm dying to hear your answers. Slate Pluser Martha Berger asks what I think we could reframe as the Framer fantasy dinner party question. Martha asks, if you could sit down and clarify some issue with the writers of the Constitution, what would it be? And Martha suggests, would you ask what they really wanted to do with the separation of church and state? Would you like to chat with them about the scope of the Second Amendment? Any thoughts on if you could sit down, or if we could transport a framer to the stage, what would you ask them to get clarity on?
I just want to say I would beg them to take out the part of the Constitution that creates the Supreme Court. I think that was a huge mistake almost from the moment it happened. It's only gotten worse with time. It's a simple fix. Take out your pen, and we'd be a whole lot better off.
Fair. Okay. Madiba, what would you like to ask one of the framers with the caveat that Mark says you could not wear pants while doing so?
Well, I don't think I would have a question. I think I would have a statement. That's just, I'm a person. Yeah. So.
Justice Eddins, is there anything that you would like to seek clarification from Thomas Jefferson et al.?
Well, in addition to what Madiba said, I would say, why are women disrespected?
Justice Todd Eddins is an Associate Justice of the Hawaii Supreme Court, and if you want a lesson in how to answer maximalist originalism, we really recommend that you go right home and read his astounding opinion in State v. Wilson. And Madiba Dennie is author of the imminently to be published, get your pre-orders in now, The Originalism Trap, How Extremists Stole the Constitution and How We the People Can Take It Back. Madiba really helped us think through so much of this series, so a huge thank you to you. Please go out and buy her book. Mark Stern, my ride or die jurisprudence wingman, thank you for your insight, your skepticism, your support at the right moments, your unwillingness to just sob into your beer when I want to do that. This has been an epic originalism journey we have embarked on together, and there's no one I would have rather been with, so thank you. Please, audience, thank these astounding people. And that is a wrap for this episode of Amicus. Thank you so much for listening, and thank you so much for your letters and your questions, and especially thank you for your thoughts in the last couple of weeks about originalism, what's right, what's wrong, and what to do about it. You can always keep in touch at amicus@slate.com, and you can find us at facebook.com/Amicus Podcast. Sarah Birmingham is Amicus's senior producer with help from Patrick Fort. Alicia Montgomery is vice president of audio at Slate. Susan Matthews is Slate's executive editor, and Ben Richmond is our senior director of operations. We'll be back with another episode of Amicus on Saturday. Until then, hang on in there.
The Coca-Cola Company, Keurig Dr. Pepper, and PepsiCo are bringing consumers more choices with less sugar than ever before. From sparkling, flavored, and bottled waters to zero-sugar sports drinks, teas, and sodas, consumers are taking advantage of these choices. In fact, nearly 60% of beverages sold contain zero sugar. To learn more, visit balanceus.org.